Workforce housing and affordable housing are terms we hear frequently these days, but what do they actually mean? Is there a difference between workforce housing and affordable housing? And why do the definitions matter? There are many opinions, but for policymakers at the state and local level, it's important to understand what those terms mean in a legal sense.
One of the challenges is that people use the terms workforce housing and affordable housing somewhat interchangeably in normal conversation, when in fact, workforce housing and affordable housing have very specific statutory definitions, and they mean slightly different things.
Matt Johnson is an attorney with Divine Millimet in Manchester who works frequently in the real estate field. His advice is that land use boards need to avoid personal opinions and instead adhere to state law definitions.
They're defined by statute in New Hampshire, and they're somewhat formulaic in terms of income limits. Affordable housing speaks to whether, when you combine the rent, utilities, real estate taxes, anything related to your household expenses, it shouldn't be more than 30% of the household's gross annual income. Workforce housing for owners is slightly different. Workforce housing means housing where, for a family of four, the cost is not more than 100% of the annual median income as determined by the Housing and Urban Development.
These definitions matter because New Hampshire statute requires municipalities to provide, quote, reasonable and realistic opportunities for the development of workforce housing. And with New Hampshire experiencing its most severe housing inventory shortage in history, how our communities expand workforce housing availability will be critical to the state's economic growth.
One of the challenges is that workforce housing and affordable housing are sometimes construed or thought to be equal to low-income or subsidized housing, and that's not, in fact, accurate under New Hampshire law. It is a math or a calculation formula based on incomes or percentages of a family's income, and that's what it really is. So I want to dispel that misperception in the community. What it is in many ways entry housing into the American dream.
In fact, the definition in New Hampshire law of what qualifies as workforce housing in 2022 might surprise people. According to the calculation required in RSA 674, the workforce housing statute, it translates to a home in Merrimack County with a price point up to $359,000, or in Manchester, a home up to $358,000. In Nashua, workforce housing, again under state law, would have a maximum purchase price of over $420,000 or $1,650 for a monthly rent, while in Belknap, Carroll, and Grafton counties, workforce housing translates to homes with maximum price points between $320,000 and $350,000 and rents between $1,100 and $1,300 per month.
Workforce housing has two separate definitions or two separate analyses depending on whether you own or you rent. If you own, you look at a family of four who is owning, and the test is whether it would be affordable for someone who is making 100% of the annual median income for the area.
In fact, most owners of single-family housing in New Hampshire live in what the state defines as workforce housing. Yet many communities have zoning ordinances which make expanding workforce housing difficult, if not impossible. That said, the state of New Hampshire does recognize that a community's restrictive zoning can create problems for neighboring towns and the region.
In New Hampshire law, there are a couple places where the law requires municipalities to provide for affordable housing. They can't set unreasonable conditions or make it difficult for the workforce housing to be achieved. They also have to look at regional impacts, so they cannot just look within the four corners of their town, and they must also consider potential future needs for workforce housing when they're analyzing developments.
To that end, the New Hampshire Supreme Court has weighed in on the issue of how uninviting towns can be to new housing.
The Britton v. Chester case is a New Hampshire Supreme Court case from 1991, which interestingly predates the workforce housing statute that was passed in 2010. In the Britton case, the Supreme Court was faced with a challenge to a zoning ordinance by a developer who said the way the zoning ordinance was implemented made it too difficult to be able to develop workforce housing in the town of Chester. The Supreme Court ultimately concluded that the developer was correct, that the zoning ordinance was subjective and put too much of a burden on the ability to have a workforce housing development, and therefore granted what became known as a builder's remedy, and essentially ordered that the builder could complete the project as proposed. That builder remedy has now been adopted and incorporated into New Hampshire's workforce housing statute.
So what are the long-term implications for a town and a state with less workforce housing? If the public policy position of a municipality is to make workforce housing difficult, if not impossible, to develop, that will mean fewer working-age residents. Without those workers, employers will not have the employees to expand and grow New Hampshire's economy.